The first case to come before us this morning is State of Ohio versus Austin Altomare. Both sides will have 15 minutes to argue. The appellant may reserve up to 15 minutes for rebuttal. If the appellant wishes to reserve any time, please let me know as I'm keeping the clock this morning and can let you know when you're reaching that rebuttal time. These arguments are being recorded, as I mentioned. Please stand behind the podium and don't use the names of victims or minors. As I indicated, it's being recorded. It will be also posted on the court's YouTube channel. We've read the briefs. We're ready to proceed when you are. Ms. Bremke, would you like to reserve any time for rebuttal?
I would reserve 5 minutes.
Thank you.
Ready for me?
We are. Thank you.
May it please the court, Giovanna Bremke on behalf of Mr. Altomare, judges and Judge Carr from afar. I'm here today on behalf of 5 assignments of error, and I won't get into the facts too much. Quite frankly, they're not too lengthy in my brief either. But generally, this involves a situation where there were 3 individuals at a home, CV, JB, and my client, the defendant. You'll see throughout the course of my argument that JB, it brings drugs and a gun to the home, and unfortunately, at the end of the night, CV passes away. The first assignment of error is that my client was denied his right to counsel according to the 6th Amendment because he was denied access to his counsel in the jail. So what happened here was, if we recall the times of the pandemic, Governor DeWine declared a state of emergency March 9th of 2020. Shortly after that, this incident occurred March 26th of 2020. And then my client's counsel went to go visit him in the county jail and was denied access. The following day, presumably citing the COVID-19 pandemic, the following day he files a motion for access to his client, which is denied. And the state did object to that motion as well. I cite a case, and this may not be how it's pronounced, but Getters versus United States, which is, in that case, there was a bar on attorney-client consultation for a 17-hour period where the court was in recess overnight. And in that case, they indicate that the government violates the right to effective counsel when it interferes with the counsel's ability to make independent decisions. In this case, when the counsel was denied access to his client, it was less than a month before the trial was set to begin, and the court had denied continuance. So it was a restriction on the counsel's ability to consult his client in preparation for trial. Second assignment of error is regarding the motion to suppress. The counsel had filed, my client's counsel had filed a motion to suppress based on 4 statements made by my client. Number 1, and I cite these, but I murdered my wife, just arrested me. Number 2, I shot my wife. Number 3, I was doing acid all night and there are drugs all over the house. And number 4, excuse my language on this one, but we were doing acid and shit like that and things got weird. Mr. Altomare's counsel filed for a motion to suppress those 4 statements, indicating that he was not properly Mirandized. And
Counsel, was he in custody at the time you made those 4 statements?
I figured you would ask that question. So that was also something that the court goes over in their decision. I would indicate to you that he was, and that what the counsel cites is that there were that police in similar situations are given a 24-hour cooling off period before they're questioned at all, before any statements are used. And in this case, my client had made this drug-induced, sleep-deprived, incriminating statement, and the court originally said there was no evidence of this sleep deprivation and drug-induced state, and my client's counsel amended their motion or supplemented their motion with an expert, Dr. Steinberg, who indicated that he was under the influence of substances and having difficulty with memory, and that's cited in my brief as well, and that he didn't remember statements or even remember being transported to the station. And so again, we'd ask that the convictions vacated based on him not being properly Mirandized on those statements. And third, sufficiency, and fourth, manifest weight, and lastly, a culmination of errors. So I'll go through those briefly and reserve my time, but on the sufficiency, I specifically focus on the 8 counts of possession. On transcript page 633, JB testified that the drugs were his, that he brought the drugs, he brought a backpack of drugs, and nevertheless, my client was convicted of those. Manifest weight, I cite to a lot of pages starting roughly around page 968 in the transcripts, and there's sort of 2 versions of this story here, JB's account and then my client's. But some things that I don't believe are in dispute under both accounts are that JB had brought the gun and the drugs to the house that night, and that my client had actually taken the stand and testified that he felt like he was drugged by JB and CV was drugged as well, and that JB started, I think the quote was, talking crazy. And the physical evidence where the casings were found, which would match my client's version of those events. And significantly as well, that night, JB didn't answer any calls from the police at all. It wasn't until much later that they were able to speak with him. And lastly, again, the cumulative error doctrine, taking into consideration all of these errors, that there was enough to vacate the conviction. I reserve the rest of my time. Thank you.
Thank you, Ms. Brown. We will have full 5 minutes for rebuttal.
Hi, may it please the court, Lindsay Poprocki of Lorain County Prosecutor's Office on behalf of the state. Despite Austin Altomare's claims on appeal, the weight of the evidence leads to the same conclusion that he volunteered to Officer Ball upon his initial encounter outside his apartment on March 6, 2020. Altomare murdered the victim, CV, with the .40 caliber Glock handgun that was located at his feet. Immediately upon his encounter with law enforcement, Officer Altomare pointed Officer Ball to the murder weapon, which was lying next to him in the ring. Without prompting, Altomare told Officer Ball, "The gun's right here, and I just murdered my wife. Just arrest me. I shot my wife. I was doing acid all night, and there are guns all over the house." After being advised of his Miranda rights and signing a Miranda rights waiver form, Altomare would later confess further to the murder during a custodial interview with detectives. The state would submit that Altomare was not in custody or under any interrogation from officers when he made those first 4 statements. Although Altomare sought to suppress the statements made during the interview with detectives, the trial court rightfully denied his motion, and this court should affirm that decision. First, the trial court correctly concluded that Altomare was properly advised of his Miranda rights prior to making any statements. This conclusion was supported by the testimony of Detective Doherty, who described how he read Altomare his Miranda rights from the Lorain Police Department waiver form, advising him of his rights. During this exchange, which was audio and video recorded, Altomare indicated that he understood his Miranda rights, that the detective verbally reviewed, and which were also contained on that Miranda rights waiver form, which had been placed in front of him. Detective Doherty proceeded to ask Altomare about his level of education and confirm that he could read and write. Detective Doherty directed Altomare to the waiver portion of the form and twice ensured that Altomare understood his rights before ultimately having Altomare sign that Miranda rights waiver form. And the waiver form as signed by Altomare was submitted into evidence at the suppression hearing. Any notion that Altomare was not advised of his Miranda rights prior to questioning should just simply be rejected. The trial court's conclusion was supported by the record that Altomare was fully advised of Miranda rights prior to questioning on multiple occasions, both verbally and in writing. As to the first assignment of error, moving back to that Altomare was denied right to his counsel because he submitted a motion for unrestricted access to his counsel, submitted a motion for unrestricted access to his client at the county jail. This, he's failed to demonstrate that his right to counsel was violated. The procedural timeline of this filing is important because it shows that Altomare suffered no prejudice by the denial of this motion.
Did Altomare have physical access to his attorney during these proceedings? Because we know that Lorain calls are recorded. In your brief, you argued that he had electronic access, but did he have physical access to his lawyer?
Yes.
Okay, so you're saying that it's simply unfettered access that is the issue, and that's not enough for an error?
Correct. He filed a motion for unrestricted access to his client beyond visiting hours on April 5th, I believe, 2021, stating that he had filed a motion for access to his client beyond regular visiting hours, and that motion, that access had been initially granted by a sergeant or someone at the county jail, and then he had not been allowed to visit beyond those visiting hours, and that prompted the motion.
So he was able to physically visit his client during the proceedings?
Yes, yes. And that's our argument, is that the state responded in opposition, stating that there were multiple ways for counsel to maintain access with Altomare, but they cited to safety and security reasons that this unrestricted access was a concern. The trial court denied the motion, but then, and also at the time that state had filed its response, it had become aware that Altomare's counsel did in fact visit Altomare at the county jail. So this notion that he was denied all access is not part of the record. And the fact that he was cut off from communicating from his client altogether is not supported either, because the trial was ultimately held in December of 2021 and not May of 2021. And the sufficiency argument, which goes to his possession of drugs conviction, Altomare would have this court believe that JB testified that all the drugs were his, that he provided all the drugs that were in the apartment. That testimony is taken out of context and does not accurately reflect JB's testimony. There are express citations that I provided in my brief that show that JB testified that he did not bring any other drugs besides some marijuana dabs and Molly to the apartment. He testified that he did not bring the blue ecstasy pill, otherwise known as MDMA, to the apartment. He testified that he observed Altomare snorting that ecstasy pill, which was crushed on a glass mirror that was later found in his bedroom, and tested positive for the ecstasy when tested by the Lorain County Drug Lab. The state would submit that there's sufficient evidence when taken together and viewed in light most favorable to it to support the conviction for possession of drugs. And as to the weight of the evidence, we would submit that the weight of the evidence leads back to those first statements volunteered ordered by Altomare to Officer Brawl upon his initial encounter outside the apartment. He murdered CV with the .40 caliber Glock handgun that was located at his feet. Those statements were offered voluntarily, and those statements were bolstered by his confession to police detectives, where he repeatedly made statements admitting to shooting CV. Ultimately, Altomare did take the stand and testify that he had no idea how CV was shot and killed. But he also admitted that he could not discredit the testimony of others because he was unable to remember what happened. He now claims on appeal that he and JB provided conflicting stories and that the physical evidence makes it plausible that JB shot and killed the victim. This statement and these assertions should be rejected outright, and the argument that the physical evidence does not support Altomare's conviction is just something that should be outright rejected as well, because immediately upon his encounter with law enforcement, he pointed law enforcement to the .40 caliber Glock that was at his feet. The .40 caliber Glock held on to Altomare's DNA when tested. .40 caliber casings were found all about the scene, and .40 caliber casing was located by the couch where the victim was found with the gunshot wound. BCI found that those casings were fired by the pistol that was located at Altomare's feet, and the physical evidence simply does not point to JB as having shot and killed CD. JB did admit to bringing a firearm to the scene, to the apartment, but testified that he left that firearm in his backpack the entire time, and when the officers processed the scene, it was located in that backpack. No 9mm casings were located anywhere about the scene. The credibility of the witnesses is obviously left for the trial court, and the evidence does not weigh heavily in favor or against the conviction here, and there's no persuasive reason for this court to reject the jury's determination. And as to the cumulative error doctrine, Altomare has given no basis for this argument. He simply cited this court to an incredibly error-free trial in his brief, but cited to no amount of errors during the trial, only to sufficiency and manifest weight, but no trial court errors. And the state would simply ask this court to affirm the trial court's judgment and conviction. Thank you.
Thank you.
I just wanted to clarify 2 points in my rebuttal here. Number one, there was statements made about memoranda and that they were warnings and that they were made and that there was something signed, but there was a defense expert, and again, I think that that's important, that's part of the record here, that indicates that there was a sleep-deprived and drug-induced state. And so part of Miranda warnings are not just be given them, but understanding them. And I think the defense expert made it clear that that's not something that somebody in that state could understand and voluntarily waive. Second is the unrestricted access. So Judge Lanzinger, I'm really glad that you brought that up, because I think this court has been very critical of the state listening in on calls with the defendants, in particular with their counsel, and it's been an issue brought up several times, and there's some cases pending regarding this issue. And so as to the unrestricted access, there is a lot of times where counsel has to show their client's evidence, and a defendant has a right to see that evidence before they proceed to trial, or before they proceed to a plea. That's something that's always asked. Do you know the nature of the evidence against you? And in order to make these voluntarily and knowing decisions about either a plea or proceeding to trial, they need to know the evidence against them. So to ask for, unrestricted access to allow to view those things and to be denied that, again, I say in my brief, the state didn't cite a single case that supports their position. And yet the court denied the access to counsel to allow him access to show the evidence that he needed.
Is there anything on the record indicating how many physical visits the lawyer was able to have with the defendant during the proceedings?
I can't say for sure there is or isn't. But again, I think given the nature of the recorded calls that are repeatedly an issue in this county, and the fact that, again, a client has a right to know the evidence and to see the evidence, and unrestricted access, the denial of unrestricted access is, it's not a safety issue. There's certainly opportunities for, they're literally sitting in the sheriff's headquarters here, to have a safe encounter, and that just wasn't offered in this case. So again, we ask that you reverse the convictions.
Thank you both for your presentations today. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of that decision to all parties to this appeal as well, as the decision will be posted on the Ohio Supreme Court website when it's issued. Enjoy this time.